Hello everyone. So today we'll be solving paper 1 from Patent Agent Examination 2018. So we are starting with part A. So question number 1. The central government may, if satisfied that it is necessary that a patent should be acquired from the patentee for a public purpose within the provision of Patent Act, then a notification is published in Option A, all leading newspapers. B, all leading newspapers and journals. C, official gazette. D, all of the above. So the correct option here is C, official gazette. Next question. Choose the correct options from the following. Every application for a patent shall be published under Section 11A of the Act, except in cases where the application A, in which secrecy direction is imposed under Section 35 of the Act, has been abandoned under subsection 1 of section 9 of the Act. C has been withdrawn 3 months prior to the period specified under subsection 1 of section 11A of the Act. D, all the above. So here all the options here are correct. So the correct option is D, all of the above. Next question. In case of a request for permission of making patent application outside India as per section 39 of the Act, the time frame to dispose such request by controller is A, within 30 days from the request, B, within 6 months from the request, C, within 21 days from the request, D, none of the above. So the correct option here is C, within 21 days of the request. This is given in Rule 71, where the controller shall dispose of a request made under Sub-Rule 1 within a period of 21 days from the date of filing of such request. Next question. A patent awarded by the Patent Office of India is valid in A, all Asian countries, B, all countries that adhere to TRIPS, C, Indian territory, D, all of the above. So the correct option here is C, Indian territory. Next question. One PCT application with US priority is filed on 1909-2009, and for filing national phase application in India, the applicant needs to file within. So here we have to calculate 30-31 months period from this date. So the correct option will be A, 1904-2012. Question number 6. A patent applicant may file a patent infringement suit within the provision of Act only after A, publication of patent application, B, grant of patent application, C, priority date of a patent application, D, date of filing of complete specification. So here we can file an infringement only after the patent is granted. So the correct option here will be B, grant of patent application. Next question, question number 7. As per the Patent Act 1970, the first compulsory license granted in India to it is Natco Pharma on 9th March 2012. So we have seen this in last year's paper also, that is May 2022. So the correct option is A, Natco Pharma. Question number 8. Method of committing theft is not patentable in accordance to one of the sections of the Patent Act 1970. Find out the relevant section from the following. A. Section 3C, B. Section 3B, C. Section 3A, and D. Section 3D. So 3C is a mere discovery of scientific principle. 3B is invention that is contrary to public order or morality. Then 3A is invention which is frivolous, and 3D is mere discovery of a new form of a substance. So the correct option here is B, that is section B. Question number 9. As per the Patent Act, the term of a patent of addition filed on 13/04/2012, granted on 15/01/2015, with regard to complete specification of an ordinary patent application filed on 15/07/2008, granted on 17/09/2011, is up to, considering that neither one is revoked prior to the term of the validity. So here it is a patent of addition. So the complete specification was filed on 15/7/2008. So we will calculate 20 years from this 2008, that is 2028. So the correct option here is B, 15/07/2028. Question number 10. An appeal shall not lie to the appellate board as per the Patent Act for the following options. A. Refusal decision of a patent application under Section 15 of the Act. An application is deemed to be abandoned under Section 21 of the Act. Decision of controller with regard to compulsory license under Section 84 of the Act. The decision related to post-grant opposition under Section 25(4) of the Act. So here, appeal shall not lie to appellate board only when an application is deemed to be abandoned under Section 21 of the Act. So the correct option is B. Question number 11. The period for which an application for a patent shall not ordinarily be open to public in Patent Office Journal from the date of filing or the date of priority of the application, whichever is earlier as per the provision of the Act, assume that there is no request for early publication. So the period for which an application for patent shall not ordinarily be open. So it will not be ordinarily open till it is published. So that is 18 months. So the correct option is 18 months. An Indian applicant has filed an ordinary patent application before Patent Office by filing provisional specification on 12th of May 2011. Assuming no post dating of the application, find out the correct option from the following. A. The applicant filed a complete specification on 12/8/2012 after filing Form 4 on 11/5/2012 for 3 months extension. B. The applicant filed complete specification on 12/5/2012. The applicant filed a petition under 138 of the prevailing rules and submitted the complete specification on 12/6/2012. None of the above. So here only option B seems correct, that the applicant filed complete specification on 12/5/2012. So correct option will be B. Question number 13. As per the Patent Act, the qualification required for a registered patent agent to work as the technical member of the appellate board is A. Master's degree in science with at least 8 years functioned as a registered patent agent. No. Degree in engineering or technology or master degree in science with at least 10 years function as a registered patent agent. C. Bachelor degree in engineering or technology or science with a law degree. D. All of the above. So here option B is correct. That is degree in engineering or technology or master's degree in science with at least 10 years functioned as a registered patent agent. So that can function as a member of the appellate board. Question number 14. As per the Patent Act, Register of Patents shall contain A. Names and addresses of grantees of patent, B. Revocations of patent, C. Notifications of assignment and of transmissions of patent, D. All of the above. So it will contain all of the above. So correct option is D. Question number 15. Any person interested may make an application to the controller for granting compulsory license on patent as per the Patent Act in the following grounds. A. That the patented invention is not available to the public at a reasonably affordable price. B. That the patented invention is reserved for non-commercial purpose. C. That the patented invention is imported with immediate effect. D. None of the above. So here option A, that the patented invention is not available to the public at reasonably affordable price is correct. And this is given in section 84, that is compulsory licenses. Next question. Question number 16. A researcher finds an idea on recycling of biodegradable plastic. How does he proceed for patenting his idea? A. He needs to publish in scientific journal and has to wait for invitation from Patent Office. B. He needs to submit provisional specification and subsequently file complete specification before the Patent Office. C. Both A and B. D. None of the above. So B. He needs to submit a provisional specification and subsequently to file complete specification before the Patent Office. This is the correct option. Question number 17. The invention as per Patent Act 1970 incorporates A. Capable of industrial application, B. An inventive step, C. A new product or process, D. All of the above. So correct option here is D. All of the above. 18. Identify from the following patented products for which compulsory license are available for export, which is entitled for manufacture and export to any country having insufficient no manufacturing capacity to address public health problems as per the Patent Act. A. Disaster management related device. B. Pharmaceutical products. C. Food products. D. All of the above. This is given in section 92A, which is a compulsory license for export of patented pharmaceutical products in certain exceptional cases. So the correct option here is B, pharmaceutical products. Question number 19. When a patent completes its full term of 20 years within the provision of the Patent Act, it A may be renewed for a further period of 10 years. B may be renewed only under special circumstances, may be renewed for a period of 5 years, shall not be renewed. So correct option is D, shall not be renewed. Question number 20. A seized patent due to non-payment of renewal fee may be restored by filing an application for restoration with prescribed fee as per the Patent Act. A. Within 12 months of the date on which the patent ceased to have effect. B. Within 18 months. C. Within 48 months. D. None of the above. So here the correct option is B, within 18 months. So this is given in section 60, that is application for restoration of lapse patent, and the form for this is form number 15. The submission of proof of right to make an application for a patent made by virtue of an assignment as per the Act shall be within a prescribed period of A. With the application or within 3 months from the date of application. B. With the application or 9 months from the date of application. C. With the application or 6 months from the date of application. D. With the application or 12 months from the date of application. So the correct option here is C. With the application or 6 months from the date of application. This is given in Rule 12 of Form 3, that is 6 months, and the section is Section 8, Statement and Undertaking. Question number 22. Find out from the following which is not the ground for opposition under Section 25(1) of the Patent Act. A. That the request for examination pursuant to the filing of complete specification has not been filed by the applicant himself, that the complete specification does not sufficiently and clearly describe the invention or the method by which is to be performed, that the applicant has failed to disclose the controller the information required by Section 8 or has furnished the information which in any material particular was false to his knowledge. D. That the patentee or the person under or through whom he claims wrongfully obtained the invention or any part thereof from him or from a person under or through whom he claims. So here B, C and D are grounds of opposition. Therefore the correct option is A, that the request for examination pursuant to the filing of complete specification has not been filed by the applicant himself. Next question, question number 23. International application as per the Patent Act 1970 means an application filed in WTO. B. An application filed under Hague Agreement. An application for patent made in accordance with the Patent Cooperation Treaty. An application for patent made in accordance with the Budapest Treaty. So the correct option is C. An application for the patent made in accordance with the Patent Cooperation Treaty. Next question 24. Discovery of a new galaxy is not patentable. A. As per section 3C, as per section 3K, as per section 3D, as per section 3B. So the correct option here is 3C, that is mere discovery of a scientific principle or the formation of an abstract theory or discovery of a living thing or non-living substance occurring in nature. So A. Question number 25. Definition of capable of industrial application in relation to the invention as per the Patent Act means A. That the invention is capable of being made or used in an industry. B. That the invention is capable of being manufactured in an industry. C. That the invention is capable of being sold by an industry. D. None of the above. So the correct option here is that the invention is capable of being made or used in the industry. A. Question number 26. An appeal may be filed against decision of controller as per the Patent Act before High Court, IPAB, District Court, all of the above. So the correct option is B, IPAB. So IPAB stands for the Intellectual Property Appellate Board, and this is given in Section 117A of the Patent Act, appeals to appellate board. So question number 27. Three applicants applied for a patent in India and patent is granted to them, and now there is a doubt amongst them regarding their patent rights. As a patent agent, what will be your clarification to your clients? Note, they are not bound by any contract. A. All are having equal undivided share in patent. B. First name holder in the patent application shall get major share. Sharing shall be based on the alphabetical order. Sharing shall be based on the date of birth. So here all are having equal and undivided share in patents. So A is the correct option. This is given in section 50, that is right of co-owners, where the first point is that the co-owners will get equal and undivided share if there is no agreement between them. So moving towards the next question, question number 28. A patent shall be deemed to be revoked in public interest by the central government. A. After appealing in the IPAB against the patentee and notification in newspaper. B. After serving a notice to the patentee and notification in the newspaper. After hearing the patentee and making a declaration to that effect in the official gazette. D. None of the above. So the correct option is C. After hearing the patentee and making a declaration to that effect in official gazette. Question number 29. If an article is sold by manufacturer with engraved with the word patent falsely, then he shall be punishable for such venture within the provision of the Patent Act by A. Imprisonment for 2 years, fine which may be extended to rupees 1 lakh, imprisonment of 1 year, and fine of rupees 50,000, all of the above. So here the correct option is B. Fine which may be extended to 1 lakh rupees, and this is given in section 120, that is unauthorized claim of patent rights, where it is written that one shall be punishable with a fine which may be extended to 1 lakh rupees if he. Last question, an applicant has filed an international application on 5/07/2012 based on a provisional application in India on 8/8/2011, and again filed a national phase application in India on 10/9/2013, and if the said national phase application is granted on 24/6/2016, then the term of the said patent application shall be up to, considering that the patent is not revoked prior to the term of validity. So the priority date is 8/8/2011, and the international application was filed on 5/7/2012. So this will be the date where the complete specification was filed. So from this we have to calculate 20 years. So the correct option here is A, 05/07/2032. So here we finish part A of 2018 paper 1. Now we'll see part B. So this is true or false type questions. Question number 31. Amendment of an application for a patent or a complete specification or any document relating thereto at any time, either before or after grant of patent as per the provision of the Patent Act 1970. Statement 1 shall be made by way of disclaimer, correction or explanation and incorporation of actual fact. Statement 2 shall be allowed though it describes matter not in substance or shown in the specification before the amendment. So here the second statement is false, whereas statement 1 is true. So the correct option is A. Question number 32. Mr. Rao is a researcher from a reputed institute in Bangalore and has filed an ordinary patent application before Patent Office, though he has published the same subject matter in an international journal 5 years back before the filing date of the above mentioned patent application. As he is confident regarding the fact that the author of the journal and the patent applicant being same, and his application shall not be refused within the provision of the Patent Act. So this is false. Second, Mr. Rao is a researcher of a reputed institute of Bangalore and has filed one ordinary patent application before the Patent Office, though he has published the same matter in an international journal after the filing date of the above mentioned patent application, as he is confident regarding the fact that the author of the journal and patent application being same, and his application shall not be refused within the provision of the Patent Act. So this is true. So correct option is B. Statement 1 is false and statement 2 is true. True. Question number 33. An application to the controller for the review of his own decision as per the Patent Act within the provision of prevailing patent rules shall be made in Form 24 within 1 month from the date of communication of such decision to the applicant or within such further period not exceeding 1 month thereafter, as the controller may, on a request made in Form 4, stating all the grounds on which review is sought. So this is true. And statement second, an application to the controller for the review of his own decision as per the Patent Act within the provision of prevailing patent rules shall be made in Form 24 within 6 months from the date of the communication of such decision to the applicant or within such further period not exceeding 1 month thereafter. As so within, it's not within 6 months, so this is false. So the correct option is A. Question number 34. Company X is having place of business at US and filed initial application at USPTO, and after 6 months from the US application, the company has done some modification and filed another application at USPTO. Within 12 months from the date of first US filing, Company X filed an Indian application claiming priority from earlier two applications from US. Statement 1. Company X is allowed only to claim pertaining to earlier priority and therefore controller refused it. Company X is allowed to claim both the priorities, and the priority date of the application is the date on which it was first disclosed. So here statement 1 is false, whereas statement 2 is true. So the correct option is B. Next question 35. As per Act, claim or claims of complete specification shall 1. Relate to single invention, and 2. Relate to group of inventions linked so as to form a single inventive concept. So both are true. So correct option is D. Question 36. For any proceedings before the controller as per the Patent Act 1970, he shall have the power of a civil court while trying a suit under the Code of Civil Procedure 1908 in respect to the following matters. A. Summoning of any person and receiving evidences on affidavits. This is true. And power for setting aside order passed ex parte on application made within the prescribed time and in the prescribed manner. This is also true. So the section for this is section 77, where the controller to have certain powers of a civil court. So they have given this true. So both are true. Therefore, the correct option is D. Moving towards question 37. An applicant X and applicant Y filed a patent application jointly before Patent Office. The application shall be examined on filing a request for examination within the prescribed time as per the provision of the Act by either X or Y. So this is true. And second statement is applicant X and applicant Y file a patent application jointly before the Indian Patent Office. The applicant shall be examined on filing a request to examination within the prescribed time as per the provision of Act by any other interested person. This is also true. So both are true. Therefore, the correct option is D. Question number 38. As per the Patent Act 1970, if the applicant mentions a biological material in the specification and if such material is not available to the public, then the application shall be completed by depositing the material to an international depository authority under the Budapest Treaty not later than the date of the filing date. Not later than the date of filing the patent application in India, and reference thereof shall be made in the specification within 3 months from the date of filing of application. Yes, this is true, and this is given in section 10, complete specification. Then second statement, as per the Patent Act 1970, if the applicant mentions a biological material in the specification and if it is not available to public, then he does not have to deposit the biological material to any international depository authority under the Budapest Treaty. This is false. So first is true, second is false. Therefore, the correct option is A. Question number 39. As per the provisions of the Patent Act 1970, a patentee may, at any time after grant, offer to surrender his patent. This is true. And the second is, as per the provision of the Patent Act 1970, a patentee may offer to surrender his patent only after 3 years from the date of grant of patent. This is false. So the correct option is A. Last question. As per the provision of the Patent Act, a patent of addition shall be granted before the date of grant of patent for the main invention. No, a patent of addition cannot be granted before the grant of patent of the main invention. So this is false. And the second statement is, as per the provision of the Patent Act, the patent of addition shall be refused on the ground only that the invention claimed in complete specification does not involve any inventive step having regard to any publication or use of main invention described in the complete specification relating thereto. This is true. So here the correct option will be B. First is false, second is true. Now we'll see part C, that is for 30 marks, and it consists of 10 MCQ questions for 3 marks each. So question number 1 is, a national or regional patent office grants a patent. The following regional patent office operative at present is or are A. ARIPO, B. WIPO, C. EPO, and D. EAPO. So here the correct options are A, C, and D, because WIPO is not a national or regional patent office. Then question number 42. If any non-registered patent agent practices before Patent Office, he shall be punishable within provision of the Patent Act A. with a fine of 3 lakh rupees for first offence and 6 lakh rupees in case of second offence, with 1 lakh rupees only for each offence, with 1 lakh rupees for first offence, D. with 5 lakh rupees for second offence or subsequent offence. So this is given in section 123, practice by non-registered patent agents, and therefore option C and D are correct here. That is 1 lakh rupees for first offence and 5 lakh rupees for second offence or subsequent offence. Now next question, question number 43. India is a member of the following international treaty: A. PCT, B. Paris Convention, C. both A and B. So here PCT also India is a member, Paris Convention is also a member, therefore C is also correct. So A, B and C, both all the three are correct. Question number 44. An applicant has received a direction from the controller under section 16 of the Patent Act. Find out the correct options of further act by the applicant. So section 16 is power of controller to make orders respecting to division of applications. So here option A is he may file divisional application before grant. Yes, he may file. B, he may ask an oral hearing to convince the controller that the invention comes under single inventive concept. This can also be true. C, he may forego second invention. This can also be true. He may file divisional application for the second invention after the grant of first one. This cannot be true. So here the correct options are A, B and C. Question 45. An application for a patent for an invention may be made by A. True and first inventor, B. Assignee of a true and first inventor, C. Legal representative of true and first inventor, D. None of the above. Here for A, B and C are correct. Question number 46. Which of the following sections are appealable against the decision, order or direction of the controller under the provision of the Act? So which of the sections are appealable? A. Section 15 and Section 16 of the Act. B. Section 21 of the Act. C. Section 54, 57, 60 of the Act. And D. Section 17, 18, 19 of the Act. So here section 21 is time for putting application in order for grant. So this cannot be appealed. So therefore all other sections are appealable. So A, C and D are correct. Now moving towards question 47. Which of the following are not patentable as per the provision of the Patent Act? A surgical instrument, a computer program, discovery of any living thing, a clock having 10 hours and each hour divided in 100 minutes. So all the four are not patentable. A, B, C, D, all the four options are correct. Next question 48. There are various modes for the revocation of patent within the provision of the Patent Act. They are classified as follows. Find out the correct options. Revocation by appellate board, revocation by district court, revocation by controller, revocation by central government. So district court cannot revoke a patent. Therefore, A, C and D are correct. Question number 49. Applicant A has been granted a patent as per the Patent Act. The exclusive right would be conferred upon A to prevent third parties who do not have his consent, A for making, B for selling, C for importing, D none of the above. So A, B, C are correct. Making, selling, importing. Last question. One patent of a reputed company D in steel industry has been seized due to non-payment of renewal fee, and D has applied for restoration with prescribed fee as prescribed in the Act and rules with reasons thereof. Suddenly, another company of the same industry opposes the request of restoration of D in the following grounds. We find out the appropriate grounds from the following. A. That the patented invention is not worked in the territory of India. B. That the failure to pay renewal fee was not unintentional. C. That the patented invention is not available to the public in reasonable price. D. That there has been undue delay in making the application. So here B and C options are correct. That the failure to pay the renewal fee was not unintentional and that there has been undue delay in making the application. So here we finish the MCQ paper, that is paper 1 from the year 2018. Next we will solve patent agent examination 2016 paper 1. Thank you for watching.